If you have a child with any kind of special needs, you're going to want to tune in today because we're going to be talking about what parents of kiddos with special needs need to know when it comes to planning for life, long term planning, estate planning, all the things. My guest here today is Adrian Gray. She is the owner and founder of Grace Estate Law, and she's been working in this area for many years and brings a wealth of experience, especially from the Social Security Administration. And so she's going to talk to us about benefits and planning and all the things. So, Adrian, I'm so happy to have you here.
Thank you for having me.
Excellent. Well, let's just dive right in. We were talking a little bit before what it constitutes a special needs child.
I would say a special needs child is going to be someone who is going to need lifelong support due to a physical or mental disability or combination of those things. So, probably someone who's not going to be working full time.
And of course, this is a whole spectrum of needs. So I realize when we're talking about this, it may be very evident at the beginning of the child's life that they're going to require special needs. And then for other types of disabilities, it may not come into play until later.
Right. We see in our guardianship practice and our special needs planning practice a range of disabilities. So we definitely see developmental disabilities. So these are conditions that children are born with. For example, Down syndrome, mosaic or non-mosaic, trisomy issues. Those are all genetic type conditions. Autism is a very common one. Some children are diagnosed early on, like when they're a toddler. Other children aren't diagnosed till they're teens, even. So we see a range of disabilities. We see kids also who have physical disability that has manifested through their various conditions. We've seen kids who've had disabilities like seizures manifest into all kinds of complications because they had so many seizures as a child, and over their life they end up having surgeries to reduce the seizures. They have even like brain injury and damage from the seizure activity and from the seizures themselves and from the surgeries themselves that cause them to become more disabled. And then we also have individuals with autism, but also significant mental health problems like schizoaffective disorder, schizophrenia, bipolar, that are going to make their life a little bit more challenging and require a supporter.
When are parents contacting you along that journey? Like if you get a diagnosis, say, an autism diagnosis early on, do they know to reach out to a guardianship attorney right away, or how does that usually work?
That's a great question. A lot of parents don't know to reach out until they're getting close to their child being 18, mostly because the school district has a transition services program and is educating them about the things they need to start thinking about. Your child is going to be 18 in the next few years. Here are the things you need to think about. But a few times we have been contacted by folks early on realizing that, their child does have special needs and they want to create estate planning and special needs planning early on, just to give them that peace of mind that they're putting in place caregivers who are going to be just as supportive and caring and accommodating as they are.
And so when parents contact you, what are some of the first things you need to find out? Like what are you kind of what questions are you asking? What do they need to be prepared for?
So parents are reaching out to me for two reasons. One reason is for special needs planning, and the other is for guardianship. They want to know, do I have a child where I'm going to need to be their legal guardian even after they're 18, such that I can continue making all the healthcare decisions for them, all the financial decisions for them, and make sure I can protect them just as I would, a minor child. And so the things I need to know have to do with their disability. So I need to know how limiting is their disability, because that can tell me whether guardianship makes sense or whether we might need to pursue an alternative to guardianship. So I like to look at medical records. I like to look at neuropsychological reports and school records like IEPs, if they have that. That tells me how disabled the child is and whether they're going to need the legal protection of a guardianship.
Are there decisions that need to be made before a child turns 18 that can impact the benefits that they receive?
Yes. When children are turning 18, they are qualified on their own to apply for supplemental security income. So, this is a disability program through the Social Security Act that provides a disability payment for individuals who won't be able to work at a full time gainful level, but who also don't have any kind of work history. So, this program is needs based, and so it's based on income and resources. You can't have more than $2,000 in assets. That has been the rule since 1989, and it hasn't changed since then. And so parents need to be thinking about making sure they're not putting money in their disabled child's name, and making sure like grandparents aren't leaving inheritances to them, and aunts and uncles and other family members that could disqualify them for that program. And also being mindful of any income streams. So, for a child who's profoundly disabled, we probably don't have to worry about job income.
Right.
But if their parents are getting a divorce and we're thinking about child support, and whether we might need to be providing child support past 18, that's an income stream we might need to start thinking about and planning for.
One of the things we were discussing before we started today was just that child support beyond the age of 18 can then be deemed income to the child.
Correct. Under Social Security's rules, so this is a federal benefits program. So the federal benefit rule is child support payable to a child who's over the age of 18. And this in Texas, that's going to be a disabled child, is 100% deemed to them as if it's their income. Even though our state law says, the obligee gets that income and that's their income, Social Security treats it as income to the child. And so parents who want to receive child support for a disabled child after 18 and over their lifetime need a plan for that appropriately if they also want to take advantage of SSI and the Medicaid benefits that come with SSI.
Okay, so we've already been talking about SSI, but let's talk a little bit more about what is that benefit plan and what do you need to show to qualify for your child to be receiving benefits under that?
So for SSI, you have to show two things. You need to show need, so financial need, lack of income, lack of resources, because they're not going to be able to work. And then you also need to show disability under Social Security's rules. You have to show that this person is unable to work 40 hours a week, and not be gainfully employed, and has medically determinable impairments, whether physical or mental, that prevent them from being able to work. And there's a framework of rules that are really complex under the Social Security laws for making that determination. And I help parents figure out if their child's going to fit within those framework of rules that'll qualify them for disability.
And just as you're talking about that, I mean, I'm just wondering, like, how many professionals are involved? I mean, who are the ones who are giving the opinion? If you're going to be applying for these benefits, does your pediatrician, for example, provide a report, or are they being examined by a special doctor through the Social Security office?
Yeah, so it depends on how documented this disability is. What I'm finding is it depends on the disability to how documented it is. For example, a parent of a child with Down syndrome, that's heavily documented from before birth even. And at birth, they have genetic testing. So my parents with children with Down syndrome come to me with genetic testing. Whereas parents with autism tend to get a diagnosis early on. Their child is identified, like say around 2 to 4 years old. And then their child's identified and they're placed in special education. And I see a lot of parents not doing much more after that. And so I have to talk to parents about maybe getting a reevaluation and assessment for adulthood, to show both Social Security and a probate court on guardianship how functionally impaired this child is, and that they're going to need a guardian, and then they're also going to need public benefits because they won't be able to work at a gainful level. So it could be a neuropsychologist, could be a psychiatrist, could be other medical doctors.
And so once the child is determined to be disabled, then what are the next steps? Because we're talking guardianship, we're talking special needs trust, and we're talking social security benefits. So it all gets so overwhelming. And I'm just
Absolutely.
imagining, a parent who's just trying to make sure that their child's going to be provided for and be okay. All of a sudden, all these legal terms are being thrown at them, and it'd be hard to distinguish.
That is definitely the number one complaint I get from parents is I feel overwhelmed. There's all these things I have to think about. Um, and they are really important. And I feel they are all really intertwined because as your child's turning 18, you want to start ahead of that. 18's really this presumptive point where the law says you have full capacity,
The
even,
child does.
yeah,
As a parent, you lose everything.
that's right.
You call to schedule a doctor's appointment and they won't talk to you.
Correct. And so that's kind of baffling to a lot of parents generally. So if you want legal protections in place on that 18th birthday, then you need to back it up and start way earlier. So I like talking to parents when their child is 16. A lot of things that we'll do is we'll start by making the parents' estate plan if they haven't created one already, because we have a plan that they're going to be getting guardianship and also applying for public benefits that are income and resource tested. We want to put plans in place first. So if mom or dad dies and leaves an inheritance, that's going to be in protected trust that Social Security will exempt from their normal rules on counting resources, and the child will remain eligible for SSI and Medicaid at 18. Also, what parents don't realize is guardianship is a very intrusive process. You're going before a probate judge. Texas treats guardianship the same way we would treat a criminal being prosecuted. We're stripping an individual of all of their rights and freedoms, and we're giving it to their guardian, their caregiver. And so we're going to give them an attorney. It is a little bit of an adversarial process, and that the child is going to have their own legal counsel representing them. We're also required to notify family members about this guardianship. So other parents, conservators, adult siblings will have to be notified. And so because of this, we want to get our ducks in a row about whether we're certain we need this guardianship. Is this person truly legally incapacitated and in need of a legal guardian to protect them for the rest of their life? So we want to start earlier documenting those things. And that may need to look like seeing the doctor, getting a medical evaluation, getting updated neuropsychological reports on someone with autism who has functional limitations in social interactions and communication, where they're going to need a lot of support.
Yeah, and I'm just wondering too, because sometimes, when the child's under your guidance and direction, they're under 18, when they become that adult, you may not have recognized the impairment as being as all encompassing as it is. Like if they really can't go get a job, right?
Yeah, it looks a
And
little different.
it looks a little different. And and I know with autism it's such a broad spectrum. So we have kids who go off to college and have great careers and, rewarding lives and relationships. And then you have children who really just can't. Um, and so if a child's already turned 18, let's say that they're 20, and you
Mhm.
just now as a parent are realizing, oh my gosh, my child really isn't going to be able to be self-sufficient, and you didn't take any of those steps, is it too late?
No, it's not too late. And I've definitely had parents try. And there's no penalty for that at all, because the Texas legislature does ask parents and prospective guardians to consider alternatives to guardianship. And if there is a feasible alternative, try that first. And if it doesn't work out, then, that's a good thing. You can show the judge, you can show the probate court, look, we tried to go without the guardianship, but here's what we ran into. And some of the things that I see parents running into are like talking to doctors, scheduling surgeries. So one example, I had a young woman, she was able to fully communicate verbally her needs with her mother. She even tried working in the workplace. She could drive. She got her driver's license. But she had a lot of disability on the autism spectrum in terms of learning and intellect. She had borderline intellectual disability. And she also had bipolar schizoaffective disorder. And so decision making was really challenging, and especially when it came to healthcare decisions. And they were contemplating a surgery that would help with weight loss and help maybe reduce some of the health problems the individual was having, like diabetes and cholesterol and things. But the doctors didn't feel like this individual had enough decision making capacity to consent to that type of surgery. And I had another case where the individual suffered from a seizure disorder, and there was an experimental surgery that was being offered. And in order to get into this experimental surgery, they needed someone who could consent. And they had totally neglected to go through the guardianship process, and they basically missed this window of opportunity to participate in this study because they didn't already have the guardianship, and it was going to take about 6 months to get done. So it's okay. We can go to the courts at any point in time, but it is better to do it sooner rather than later because these things come up. So,
And so, sort of in an ideal situation, if the sooner the better. But let's say you've got the 16-year-old, what should the parents be getting in place?
I think the parents should be getting in place at least a special needs trust. If they have a young adult who they know to be disabled cognitively or mentally, even some of our, children who have typical behaviors but maybe have mental health, they can be more prone to financial exploitation. And so if you have any child that's got a disability or a mental health diagnosis, you really ought to consider a trust, because we want to put some protections in place where we're not leaving them a whole bunch of money outright where they could be exploited by third parties. And people who suffer from mental health problems or cognitive issues or developmental or learning disabilities are, more highly susceptible to being exploited. So at a minimum, parents when their child is reaching 16 should be putting those trusts in place and preparing.
That makes sense. I know how easy it is for people to be exploited these days,
Yes.
regardless of mental capacity. I mean, it just
Right?
is, it's a crazy world. So get the special needs trusts in place, and then prepare for guardianship if that's necessary.
Yes. And at that time, we can also discuss with the parents what those limitations that their child has look like and whether they might need a guardianship due to the limitations, or they might be able to pursue alternatives to guardianship. And alternatives could look like power of attorney forms that a child signs over to their parent so that their parent can act on their behalf and help them in financial transactions and medical decision making when they're not able to.
And at least like a HIPAA release
A
and
HIPAA
things that
release.
allow
Yes,
communication to flow
exactly.
with decision makers. Now, that's all well and good when parents are on the same team and they're communicating well and they're co-parenting well.
Yes.
But as we know, that is not the case, and especially with a special needs, child. I just know from experience that creates a lot of stress and strain on families, and that can
Yes.
often result in divorce. So let's talk about sort of what would be ideal for divorcing parents with a special needs child to know, and then sort of the realities of how do we make the best out of a bad situation.
Good point. Good point. Because it's not all perfect and roses.
No. So
Um,
ideally, if the parents in the divorce can agree, what are the important things
yeah.
they should be agreeing on?
If the parents can make an agreement and they're good at co-parenting, Texas does allow parents who are appointed joint managing conservators to be co-guardian of their child at 18. I don't really recommend it because generally with a special needs child, there is that one parent that's probably providing 80% of the child's needs. And if that's the case, it makes more sense for that parent to be the guardian because realistically, in the real world, what we see is when two people are appointed in the same role, third parties don't want to consult with just one of them. Even if we have orders and paperwork from the court that say third parties can deal with each individual, without the other being present, they don't feel comfortable with that because they don't want to make a decision with one guardian and then the other one come back and say, well, wait a minute, you didn't include me in this. And so, you
It
know,
creates liability for
yeah,
third-party providers, and I think that's one
it
of the things
does.
that even divorce lawyers don't understand, is we think joint managing conservatorship is this, this that all parents are entitled to that, and therefore they should be entitled to joint guardianship. But when it comes to decision making, it just puts a lot of burden on third parties,
It does.
and that can mean that the child isn't going to get the care if the third party doesn't want to be bothered.
And I have also seen where it got frustrated. So, like a parent who is the caregiver and who does take the child to the doctor, and then an order saying, but this other parent can get medical records. I've seen where the other parent abused the medical record
Yeah.
requests to the point where it like ruined the relationship for the caregiving parent. And so I think it makes more sense to put all the duties and responsibilities into the parent who's more likely to be the caregiver. And so, what's the ideal situation? Have the divorcing parents make an agreement in advance in their family law orders about who's going to seek guardianship, who's going to be that guardian when the child turns 18. Also, who's going to be making that application for the Medicaid and for the Social Security disability benefits, and who's going to be in charge of receiving those benefits and managing them for the disabled individual. If we can make those agreements up front, that would make it a lot easier going.
And it will just streamline the process. And so the other thing I think people don't understand is divorce and custody, that's done in our family courts, but guardianship is in our probate courts.
Correct. Yes.
And so, I suppose in the divorce decree, you can have language authorizing one of the parents to take the action on behalf of the child. Is that sort of
Yes.
how it would read? Have you seen good language?
I have.
Excellent.
Yeah, I have. I have seen parents make that agreement that this parent will be the one making the application for guardianship. And, I don't think I've seen a situation where it had to be enforced, where that order had to be taken to a probate court and be like, they signed on the dotted line. I think what it does is it sets the groundwork and the expectations about who's going to be doing what at 18.
Yeah.
And that's where it helps.
And it doesn't mean, as the parent who's not appointed as the guardian, who's not taking on those responsibilities, it doesn't mean that they're cut out of the loop.
No.
So can
at
you
all.
can you explain what rights a parent non-guardian has then with their regard to the adult child?
They would still have a right to be able to file into the case and receive notice of any changes that happen with the disabled child. So if they move, if they were put into a residential facility, and things of that nature, they would be entitled to notice. Whether they wanted more expanded rights, they would probably have to fight for that in the guardianship. For example, we have had people fight for like some visitation rights. That comes up every now and then in guardianship. So that might need to be worked out if the parents themselves weren't good at making agreements about that and co-parenting.
Okay. And is before the child turns 18, that's still guardianship doesn't come into play until the child turns 18, right?
Well, we can't appoint a guardian until the child turns 18, but we can actually make the application for guardianship at 17 and a half.
Okay.
So, and we want that because going back to what I was saying earlier, if there's a reason why we need to make sure that legal caregiving role, there's continuity in it on the 18th birthday and beyond, then we want to start the process a little earlier because, courts take time, right? You file your pleadings and you go through the motions and then you get in front of the judge and have your final hearing. That all takes a matter of time, and it's usually about 6 months. So,
And if the parents didn't agree on co-guardianship and they didn't agree on which parent was going to be the one who was appointed the guardian, then they're going to have a contested hearing in probate court.
potentially,
what
if
is
they
that
can't,
like?
if the parents can't make an agreement about it, then we're looking at a contested guardianship. We're looking at prolonged guardianship proceedings. We're looking at more costs, and we're looking at the risk that the probate judge gets frustrated and just appoints a private professional guardian and doesn't appoint the parents due to the conflict.
So if the parents are having the conflict, then it could be that they're going to have to be dealing with a third party
It could be.
regarding their child.
And that third party would get all these rights that the parents would normally have, like the right to make healthcare decisions, the right to make decisions about residence, where the child lives, who they see, and the terms of those visitations. So
So it seems like there's definitely an incentive for parents to reach those agreements.
I think so. I think the greater risk is losing all control and access, if they won't make an agreement.
So far we've talked about the benefits of a special needs trust because it's a way to set aside assets for the benefit of your child that won't prevent them or disqualify them from getting
Right.
Social Security benefits. You've talked a little bit about Medicaid. I want to explore that more, and then I also want to talk about what happens when parents retire and what other additional benefits the child may be entitled to.
Yeah, so in the state of Texas, we haven't taken any expanded funding from the federal government for our Medicaid. So we have a very bare bones basic Medicaid program. And in Texas, as an adult, the avenue for getting Medicaid is an SSI payment. So if you have a SSI payment because you've been deemed disabled by Social Security, you automatically receive Medicaid. So most of my parents aren't really looking for the cash benefit. They're looking for that Medicaid healthcare benefit so they can make sure their child always has healthcare coverage no matter what happens to them, especially if they were to lose their job, retire, or pass away. Their child's got that health care. So that's super important. SSI is a program that's needs-based, as I said earlier. So it's based on income and it's based on resources and it's based on you don't have eligibility for any other disability benefits, mainly because you've never worked, you're not going to work because you don't have the ability to work full-time due to your disability. However, there is a Social Security program for the disabled adult children of workers who did pay into the Social Security system and are now retired or disabled themselves or who have passed away. It's through the Title II of the Social Security Act, and it's the Disabled Adult Child Benefits. And so what we see is children start off at 18 getting SSI, and then as the parents reach retirement age, Social Security will want to move them to that program, that Disabled Adult Child program, and move them off the SSI benefits.
Is the SSI benefit pretty much the same for everyone, or is it scaled depending on like the wealth of the family, or what goes into determining the amount of the SSI benefit, and how does that change then
That's a great question.
later?
There is a max benefit. And so the max benefit for 2025 is $967 per month. And then if you are receiving a source of income, it reduces that $967 for dollar. And so there's many rules about what constitutes income. And depending on if you're receiving a stream of income, you could receive a reduction from that maximum benefit.
Okay. And then when they go into the Title II later on in life after a parent
Passes
passes
away
away,
or
when
becomes
how does
disabled or
that
retires, that benefit is tied to the parent's earnings record. So what they paid into Social Security, and it's a percentage of the family benefit. It's really complicated because individuals paying into Social Security have their own benefit, but then they have a family benefit. And I like to think of the family benefit like a pie. And we can carve up this pie for the different qualified members of the worker's family, like say a spouse, adult disabled children, minor children, if the worker passes away when their children are under 18. And so this pie can be split up between those members of the family. And so the benefit for a disabled adult child will be highly dependent on what is that worker's family benefit, but then also how many family members are basically eating off the pie.
got it? Okay. It makes total sense.
Yeah.
And I'm just as we're talking about sort of the adult child, maybe that you didn't take all the steps when they were younger. This process is overwhelming. And
Yes.
so if you don't take the steps to get the benefits in place while you're able to do that, it could be that these kids just won't get the benefits.
Right. Yeah. They could be missing out on tens of thousands, maybe hundreds of thousands of
Yeah.
dollars in benefits if they don't set up all of these, legal processes.
Yeah, it's so important. And I want to thank you for coming and taking time to explain some of this to us. I'm sure, I hope you found this beneficial as well, because if you know of a kiddo or you have a kiddo, this is just such important information. And we are going to leave a contact information to Grace Estate Law so you can follow up if you want to get more information from her. And we ask you to stay tuned for future episodes as we delve into the many issues affecting our families these days. Thank you so much.
Thank you.